As you know, Elizabeth Holmes has been sentenced. She is headed off to a federal prison camp in Bryan, Texas. And you can check out my other video to learn a little bit more about where she was staying during the trial and a little bit more about this federal prison camp that she's headed to. Now, remind you, she's got family, including a baby on the way. She's got a son. They are in California. This prison camp is in Texas. Now she is asking for a stay. She does not want to have to go to jail, serve in this prison camp while her appeal is out there waiting to be heard. So she's bringing forth four statutory factors that need to be considered in order for her to be able to say, hey, judge, can I just stay at home? This was just filed a few days ago. It's a little long, it's 21 pages, but that's okay. We will make our way through it. First, you have Ms. Holmes' motion for release pending appeal. Motion for release pending appeal. Please take notice that on January 23rd, 2023 at 1:30 p.m. or on such other date and time as the court may order in courtroom 4 of the above captioned court. Okay, yes. Defendant Elizabeth Holmes will and hereby does respectfully move the court to release pending appeal. Ms. Holmes makes this motion pursuant to 18 U.S.C. section 3143. The motion is based on the below memorandum of points and authorities, the record in this case, and any other matters that the court may deem appropriate. So she's got this table of contents here, and I want to highlight these four factors here because that's really what this decision is going to be made on. Is Ms. Holmes, it says, Ms. Holmes is neither a flight risk nor a danger to the community's safety. Ms. Holmes' appeal is not for the purpose of delay. Ms. Holmes' appeal will raise several substantial questions of law or fact. The appeal will result in a new trial if the issues presented are resolved in her favor. Then you'll see the conclusion. These are the cases that they're going to be citing here, the statutes and the rules. All of that is listed there. All right, let's go over the memorandum of points and authorities. It says, Ms. Holmes respectfully moves this court to release pending appeal pursuant to 18 U.S.C. 3143B. This case satisfies each of the statutory factors. Remember, I just said that this is what she's going to have to show here. Ms. Holmes is not a flight risk or a danger to the community's safety. Second, the appeal is not for purpose of delay. Third, the appeal will present several substantial questions. This was a complex, hard-fought, multi-month trial with numerous witnesses and hundreds of exhibits that produced a split verdict. Ms. Holmes filed 19 motions in limine before trial. She filed a pre-trial motion to suppress and multiple motions for a new trial after trial. The court was required to make numerous evidentiary rulings before and during trial. In sum, the record is, here's what they say, teeming with issues for appeal. This court need not conclude that it erred to recognize that this complex case involved many contested issues that produced substantial questions on appeal. Finally, if the Ninth Circuit rules in Ms. Holmes' favor on any or all of these issues on appeal, a new trial will be required. Release will facilitate Ms. Holmes' continued communication with her counsel as she litigates these issues on appeal. Of course, it's easier to communicate with your counsel if you're not behind bars. The court, and I'm not making light of that, it just is. The court should grant Ms. Holmes' motion for release pending appeal. Okay, so we're going to jump into the argument here. And then we're going to go through each of these. Then when we get to the one that talks about, well, we'll just jump to it in just a minute. As relevant here, a court may release a defendant pending appeal if it finds that the defendant, one, does not pose a flight risk and does not pose a danger to public safety. Two, the appeal is not for purpose of delay. And three, the appeal will raise a substantial question of law or fact that is, if resolved in the defendant's favor, for likely to result in a new trial. The court must find the first element and only the first element by clear and convincing evidence. It says Ms. Holmes meets each requirement. So let's step into this first one, because remember now, she's saying she's not a flight risk nor a danger to the community or community's safety. And, one of the things that's interesting to think about in this context is because she's pregnant, there is this sort of sense that she is a mother and that mothers generally don't present much harm to community safety. And I'm just saying that's the presentation you get when you see a pregnant mother, because they're carrying a child, someone that they have to take care of. And so in our minds, subconsciously, sometimes that's what we're thinking. It's harder to see mothers as someone who, especially women who are pregnant at that time. Ms. Holmes is not a flight risk and poses no danger to the community's safety. Relevant considerations on this element include the nature and circumstances of the offense charged, the history and characteristics of the defendant, including character, family ties, community ties, past conduct, and record concerning appearances at court proceedings, and criminal history, and their nature and seriousness of the defense. Seriousness of the danger to the safety of any person or community that would be posed by the defendant's release. Ms. Holmes is not a flight risk. The court has already found that Ms. Holmes is not a flight risk or danger to the community when it permitted her to remain in the community both before and after conviction. Ms. Holmes' actions during the pendency of this case affirm the court's findings. Ms. Holmes surrendered her passport and is unable to travel internationally. She has been under supervision for over 4 years. After conviction, Ms. Holmes continued to make court appearances, was interviewed by probation, has continued to report to pretrial services, and has remained in regular contact with her counsel, with whom she continually works on this case. The probation office recognized in the pre-sentence investigation report that Ms. Holmes has a flawless record with U.S. pretrial services supervision during her over 4 years under supervision. Ms. Holmes did not flee during the pendency of her case, did not flee in the immediate aftermath of her conviction or sentencing, and no evidence suggests she will flee while she pursues her appeal. She has strong ties to her partner and family, including her son and soon to be born child, that incentivize her to comply with her conditions of release. The court modified Ms. Holmes' conditions of release after her conviction in this case, which led to Ms. Holmes posting a $500,000 bond secured by her parents' only home. Those conditions and bond remain sufficient to secure her release pending appeal. Ms. Holmes also is not a danger to the community. The government has never argued to the contrary and never requested that Ms. Holmes be remanded before or after conviction. Ms. Holmes was not convicted of any crimes of violence. Ms. Holmes has no prior criminal history and has no history of violence that would suggest that she poses a risk to the community's safety. There is no threat of Ms. Holmes causing pecuniary harm given her substantial notoriety. Next up, the second factor, Ms. Holmes appeals is not for the purpose of delay. Ms. Holmes' counsel represents that the contemplated appeal is not for the purpose of delay. As discussed further, Ms. Holmes' appeal will raise substantial questions of law or fact that, if successful, would mandate a new trial. Okay, so here's where it starts to get complicated. I'm not going to spend a whole lot of time talking about each one of these because there's a lot of case law in here. And yeah, I don't want to get into that. And you probably are not ready to take a nap just yet. C, and this is the third factor, Ms. Holmes' appeal will raise several substantial questions of law or fact. This is the Ninth Circuit takes a liberal view of whether a substantial question exists for purposes of release pending appeal. Substantial questions are those that are fairly debatable or doubtful. In other words, what she's saying is that she has less to prove here. The other side really, is the party that has to be able to say, hey, no, these aren't substantial questions or fact. She gets more of the benefit of the doubt here, is what I'm trying to say. In the end, the question is simply whether the issue is one of more substance than would be necessary to a finding that it is not frivolous. Okay, so it's sort of like, if it's not frivolous, then hey, it sounds like it may meet the standard. We're not going to go through all of those, but we do want to see what these issues are that she's talking about. So the first one she's talking about is the admission of Dr. Kingshut Das expert testimony and patient impact assessment. It says Ms. Holmes may argue that the court erred in permitting Dr. Kingshut Das to present expert testimony disguised as fact testimony in violation of Federal Rule of Criminal Procedure 16 and Federal Rules of Evidence 403 and 702. So that's one of her arguments that, hey, that testimony, no, 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 no. And then the second one is admission of the evidence of CMS findings and sanctions. It says the court erred in admitting evidence of CMS sanctions, including excerpts of the CMS report, for the purpose of proving Ms. Holmes' state of mind, intent, and knowledge regarding the alleged misrepresentations about the accuracy and reliability of Theranos' blood tests. It says evidence regarding CMS's findings and sanctions in late 2015 and early 2016 are not relevant to Ms. Holmes' earlier state of mind at the time of the alleged misrepresentations. As a result, this evidence, at a minimum, lacks sufficient probative value such that the Rule 403 balancing test tilts overwhelmingly in favor of exclusion. So she's saying that evidence that was admitted should not have been admitted. And that's one of the things that they're saying, hey, this is an issue. And not only that, it says the admission of this evidence and all the related evidence that flowed from it, including the evidence of Dr. Das' expert analyses and the voiding of the test, confused the jury's assessment of Ms. Holmes' intent and state of mind and substantially prejudiced Ms. Holmes on the core issue in this case, core issue being the accuracy and reliability of Theranos' technology. All right, what was her third one? It says the admission of Theranos' 2016 voiding of Edison test results. It says, relatedly, the court erred in permitting the government to admit evidence that Theranos voided Edison test results in 2016 after all the relevant events in this case and more than a year after any relevant representations to investors. It says Ms. Holmes objected to the admission of any evidence avoiding under both rules 403 and 407. So this is another thing, another reason. They've got several of these that they're using here. Denials of motion to suppress and strike. So they're just saying, hey, during the court proceeding, we made some motions to suppress or strike. And yeah, those were not ruled in our favor. It says Ms. Holmes may raise on appeal the court's denial of her motion to suppress and related denial of an evidentiary hearing on that motion. And we're not going to go through all that. Again, a lot of case law there. Number 5, exclusion of Balwani deposition testimony. Ms. Holmes may argue that the court erred under Rule 804b3 in excluding Mr. Balwani's prior deposition testimony concerning his control and ownership of the financial model and projections shown to certain investors. Mr. Balwani's deposition testimony explained that he was responsible for the financial model, that no one else from Theranos modified it, that he revised the model so much that Ms. Holmes may not have been familiar with all the assumptions, and that Ms. Holmes never edited the model. This was critical evidence because the 3 wire fraud counts of conviction involved investors who reviewed the projections. The court's ruling that Mr. Balwani's statements were not sufficiently inculpatory because the statements do not by themselves expose Mr. Balwani to civil or criminal liability was erroneous. It says a statement against interest does not require a confession of criminal responsibility, but can be satisfied by remarks that tend to subject the declarant to criminal liability. And it's saying that the court similarly erred in determining that no circumstances corroborated Mr. Balwani's testimony. They've got information here regarding text message. Then they go on to say there were limitations on cross-examination of Dr. Adam Rosendorf. They've got a whole long list here of these. Ms. Holmes may raise an appeal on the issue of whether the court violated the Confrontation Clause by foreclosing inquiry into Dr. Rosendorf's bias. During trial, Ms. Holmes sought to cross-examine Dr. Rosendorf concerning 3 positions that he held following his tenure at Theranos. Perkin-Elmer, Invite in Ubiome. Okay, I guess that's how those are said. The questions Ms. Holmes intended to ask all went to bias, competence, or credibility. The court permitted limited questioning about Dr. Rosendorf's employment at Perkin-Elmer on the ground that it was relevant to potential issues of bias. But the court forbade Perkin-Elmer related questioning regarding the nature of any investigation, the quality of the investigation, or Dr. Rosendorf's specific role in it. The court excluded examination about Invite as inappropriate character evidence. So these are the reasons why she's saying that there were limitations on his cross-examination there, and they may be using that. Number 7, another issue that they may be bringing up, denial of motion for new trial based on Dr. Rosendorf's post-trial statements. Okay, so Dr. Rosendorf's post-trial statements at Ms. Holmes' residence and subsequent testimony warrant a new trial. The court acknowledged the unprecedented nature of the event that gave rise to this motion. The event was so troubling that the court felt compelled to hold an evidentiary hearing. At that hearing, Dr. Rosendorf did not dispute Mr. Evans' account of Dr. Rosendorf's visit or any of the statements made during their encounter. The court need not conclude that it erred to acknowledge the complex issues raised by this significant event. These issues will command serious attention on appeal. Statements and testimony from a government star witness suggesting that the government cherry-picked evidence and or testimony to make things seem worse than they were would have gravely damaged the reliability of the government's presentation of evidence and bolstered Ms. Holmes' defense. So yes, the fact that he went to her house after the trial, nobody does that. It says a jury in a new trial would probably acquit Ms. Holmes if it heard an important government witness testify that he took the extraordinary step of going to Ms. Holmes' residence to explain, among other things, that the government made things seem worse than they were at trial. This would both undermine the strength of the government's case and Dr. Rosendorf's credibility as a witness. Like, who does that? Who shows up at the person's trial, afterward and says, hey, yes, I testified, but they kind of blew this all up out of proportion. They made it seem like it was worse than it was. It really wasn't quite like that. All right. So that is another thing that she is arguing. She is also saying admission of evidence regarding alleged misrepresentations to the Department of Defense. The government represented before trial that the Department of Defense is not a victim of wire fraud as charged in the indictment. The government never disclosed under Rule 404B that it intended to present evidence that Ms. Holmes supposedly made misrepresentations to the Department of Defense. However, during trial, the government elicited testimony from Daniel Edlin intended to show that Ms. Holmes supposedly made misstatements to the Department of Defense in a PowerPoint presentation over a year and a half before any of the investors at issue in this case heard any statements. The government offered no coherent theory for why alleged misrepresentations made to the Department of Defense were a part of the charge scheme. The only purpose of the evidence was to leave the jury with the impression that if Ms. Holmes made misrepresentations, I totally lost my place. If Ms. Holmes made misrepresentations to the Department of Defense, she must have made misrepresentations to investors. So they're putting this inference in here that they just used that to, again, make her seem like this person who was just going to go on and then lie to the next people. All right, this is classic propensity evidence barred by Rule 404. Yeah, she did it before. She's likely to do it again. It says the admission of this evidence severely prejudiced Ms. Holmes as it was intended to depict her as a liar, which went to the core issue in the case. Number 9, denial of a new trial based on the government's closing argument in the Bawani trial. Ms. Holmes may raise on appeal the court's denial of her new trial motion based on the government's closing argument in Mr. Balwani's trial. The newly discovered evidence concerning the government's statements about Ms. Holmes' relationship with Mr. Balwani would have probably led to Ms. Holmes' acquittal in a new trial. The government highlighted the nature of the relationship as one between co-equals during Ms. Holmes' trial. During Mr. Balwani's trial, the government took the opposite position and highlighted Mr. Balwani's age, experience, and influence over Ms. Holmes. Um, Contrary to the court's post-trial ruling, the government's statements are newly discovered evidence. Prosecutor statements and closing arguments are admissions of a party opponent, and they've got some case law there to support their position on that. Remember, so they used that. And another thing, well, let me just finish this before I make my own little comment here. It says the government did not make a materially similar admission in Ms. Holmes' trial. For the same reason, the court erred in holding that the government's statement carried no evidentiary weight. Okay, admissions of a party opponent carry evidentiary weight. An admission from the government that Mr. Balwani's age, experience gave him significant influence over Ms. Holmes would have powerfully corroborated a key defense theme. The court's contrary ruling overlooks Ms. Holmes' testimony regarding the many areas of the company's operations, areas critical to the investors' count in which she relied on Mr. Balwani. At a minimum, whether a jury would have acquitted Ms. Holmes if she was able to use this newly discovered evidence in a new trial presents a substantial question. Remember, it just doesn't have to be frivolous. Is this a substantial question? The fact that the government in her trial said, oh no, they were co-equals, they were in this together. And then in the closing argument in his trial, they go, oh, well, no, look at, he had more age, he had more experience. He was almost a mentor to her. He took advantage of their relationship. And she's trying to use some of that as a defense. So she's saying, hey, even the government admitted that. I need to use that in a new trial because a jury would find that that is relevant to what's going on. And it's definitely relevant to the very defense that I'm bringing forward. 10, denial of a new trial motion based on the government's failure to produce information regarding the LIS database. And this is just saying to produce exculpatory emails relating to the government's failure to preserve the LIS database, despite Ms. Holmes' specific request for this information and subsequent motion practice. And then the appeal will result in a new trial if the issues presented are resolved in her favor. It says, finally, if the Ninth Circuit agrees with Ms. Holmes on any or all of the issues presented, a new trial would be required. An issue is likely to result in a new trial or the other relief listed in Section 3143B1B if the appellate court could grant such relief should it rule in defendant's favor on that issue. A defendant need not present, now get this part, a defendant need not present an appeal that will likely be successful. Rather, the question is only whether the appeal presents a non-frivolous issue that, if decided in the defense's favor, would likely result in reversal or could satisfy one of the other conditions. All right, so let's talk about the conclusion of this. The statutory factors for release pending appeal are satisfied here. Ms. Holmes is neither a flight risk nor a threat to the community. This case has a lengthy, complex record for which there are numerous substantial issues to be addressed on appeal, which, if decided in her favor, would require a new trial. Ms. Holmes has remained in constant contact with counsel throughout this case. Release will facilitate Ms. Holmes' continued communication with her counsel concerning these issues and the merits of her appeal. For all of the foregoing reasons, the court should grant Ms. Holmes' motion for release of pending appeal. There you have it. Her reasons, her basis for saying, hey, I want to stay home. I want to stay home. Can I just stay home while we pursue this appeal? And who would not want to stay home? There you go. Don't forget to like the video and subscribe to the channel. Peace.